Last case on the calendar for today, LM, mother of CM, versus Florida Department of Children and Family Services.
May it please the Court, I am Michael Upperman, and I represent the mother in this termination of parental rights appeal. I'd like to reserve 5 minutes of my time for rebuttal. The first issue I'd like to address this afternoon concerns the July 29, 2005 hearing, a hearing where the mother was not represented by counsel. The record does not contain a transcript of the July 29th hearing, but the record does contain an amended, stipulated reconstruction of the record regarding the events that occurred at that hearing.
Counsel, does the record conclusively demonstrate that the mother was not represented by counsel at the July 29th hearing?
I believe so, Your Honor. The only evidence we have of what occurred at that hearing is this stipulation. And the stipulation contains 6 numbers of the events that occurred at that hearing. I submit that they're sequentially numbered events. The very first number, number 1, begins with at the beginning of the hearing, and that's why I make the argument that these numbers occur in order based on the events that occurred at the hearing. And let me read the first paragraph of that stipulation. It says, at the beginning of the hearing, Mr. Drumming, counsel for the mother, asked to withdraw and be replaced as counsel. The mother had fired him a few minutes before the proceeding started. The magistrate granted the motion after questioning the mother. Mr. Drumming did not recall participating thereafter. So I submit, based on this first statement of the stipulation, it is clear that at the beginning of the hearing, the first thing that happened is the magistrate granted counsel's motion to withdraw. Everything that occurred after that, Mr. Drumming was not representing the mother. Now, there's some dispute apparently about what participation he had. Mr. Drumming said he doesn't recall participating. The department says that they recalled that he might have participated. Either way, we still know prior to that, based on that first paragraph of the stipulation, the court granted counsel's motion to withdraw. So anything that Mr. Drumming may have done from that point forward, he wasn't acting as the mother's counsel. He may have been acting in some other capacity, but she was unrepresented by counsel from that point forward. Now, obviously, the right to counsel in a TPR proceeding is fundamental. It's established by both rule and statute and the state and federal constitutions. The July 29th hearing was very important for several reasons. First, prior to the hearing, the mother had filed a notice that the children's maternal grandmother should be considered as for long-term relative placement. The record does not demonstrate that at any time during the July 29th hearing that this issue regarding the maternal grandmother was brought up. Had the mother been represented by counsel, this issue could have been addressed by the court. Second, at the July 29th hearing, the magistrate heard testimony from Dr. Love, the children's therapist, about the children's immediate need for permanency. The record, again, doesn't demonstrate that the mother had an opportunity to cross-examine Dr. Love, or even that there was questioning of Dr. Love by the mother. Certainly, if she was not represented by counsel, this would not have occurred. Third, the trial court considered the ICPC denial of Ms. Stanley as a possible relative placement. And without counsel, the mother was not able to challenge this ICPC denial. And most importantly, the magistrate terminated the mother's parental rights at the conclusion of the July 29th hearing. So the mother's parental rights were terminated at a hearing wherein she was not represented by counsel. I've cited the MR case from this court as an example of an appellate court that has reversed when a parent was not represented by counsel at a TPR proceeding, and therefore the court reversed the TPR order. Once the magistrate discharged Mr. Drumming at the beginning of the July 29th hearing, the magistrate either had to immediately appoint new counsel to represent the mother for the remainder of the hearing, or stop the hearing and continue it to a later date until the mother had counsel. The magistrate didn't do either of those in this case. The magistrate continued with the hearing, and the mother was not represented for the remainder of the hearing, and therefore I submit that the mother's fundamental right to counsel has been denied and the TPR order should be reversed. The second issue I'd like to address is whether or not the mother received proper notice of the March 15, 2005 advisory hearing. The hearing before the March 15th advisory hearing took place on February 22, 2005. The record is clear that the mother was not orally advised regarding the consequences for failing to appear at the March 15th hearing. The record contains a transcript of that February 22nd hearing, and there's nothing in that transcript indicating that the magistrate ever advised the mother that if she failed to appear at the advisory hearing, a consent would be entered. The only thing we have is a written form that the mother signed. Rule 8.505B and Section 39.8013A specifically state what must be included in a notice of hearing for an advisory hearing. The rule and the statute state that the notice must indicate that failure to personally appear at the advisory hearing constitutes consent to the termination of parental rights, and if you fail to appear on the date and time specified, you may lose all legal rights as a parent.
So, counsel, is your position the judge did not provide an oral warning to the mother?
Yes, I think the record's clear as to that because we have that February 22nd transcript. There is no oral warning in that transcript. All we have is this written notice. So the question before the court is the written notice sufficient? Does the written notice comply with 8.505B and Section 39.8013A? The written notice only states, quote, if I fail to appear, it could result in my child being adjudicated dependent or termination of my parental rights. It contains the second phrase from the rule and the statute, but it does not contain the first. The first phrase says, if you fail to personally appear at the advisory hearing, it will constitute a consent to the termination of parental rights. This form does not inform her of that. This form doesn't say anything about failing to appear will result in a consent. It's very different to say, on the one hand, if you fail to appear, your rights could be terminated, and on the other, if you fail to appear, a consent will be entered. The latter is what must have been included on this notice, and it was not. In the CRK case from the 4th District, the court held that the profound nature of an order terminating parental rights mandates strict adherence to statutory requirements. This notice had to strictly comply with Section 39.8013A, and it didn't. In the VDC case out of this court, the court explained that Section 39.801 does not permit a court to enter a consent on account of a parent's failure to appear at any hearing other than a properly noticed advisory or adjudicatory hearing. The mother was not properly noticed as to the advisory hearing on March 15, 2005. The notice was insufficient. It did not comply with the statute. Florida public policy obviously favors an adjudication on the merits. The mother did not get an adjudication on the merits in this case. A consent was entered. And I submit that because the notice was insufficient, the TPR order should be reversed. I'll rely on the remaining arguments in my brief, and in particular the argument that a second advisory hearing in this case was not necessary in light of the first advisory hearing, and the argument that the maternal grandmother has never been considered by the court below as a relative custodian. Other than that, I'll reserve the rest of my time for rebuttal.
Counsel, will you address the mother's excusable neglect defense to the default judgment that was entered?
Yes, Your Honor. Our position is that on that particular day, she did not show up. She explained that she didn't show up because there was an arrest warrant out for her, and she was making the necessary arrangements to have to report to jail.
So the case law, is that sufficient excusable neglect for failure to appear at the hearing?
I submit that it is, simply because she had appeared at almost every other proceeding to this date. And there have been a lot of proceedings. There had been a first advisory hearing. There have been several other proceedings, and she'd appeared at all those hearings. And on this particular date, she did have a reason. Florida law does liberally construe motions to withdraw consents. She later appeared and explained her reasoning for this. She appeared at subsequent hearings, and she had a reason as to why she did not appear. It's because of this arrest warrant. So again, I submit that Florida law does favor an adjudication on the merits. She didn't get that in this case. She provided a reason, and I think it was an abuse of discretion for the magistrate to not allow the consent to be withdrawn.
So it's your position that if since there was an arrest warrant out for the mother in this case, that constituted sufficient excusable neglect for her failure to appear at the hearing?
That's my position, Your Honor. Of course, I'll submit that my stronger argument, of course, is the argument that she did not.
Is that just in TPR cases, or does that apply to various legal proceedings?
I think the profound nature of a TPR proceeding and the rights that are at stake, if there is a reason that can be considered to be reasonable for failure to appear, that it may be appropriate for a court to withdraw a consent and allow the case to go forward for an adjudication on the merits. Again, I acknowledge that this court has to decide whether or not that's a reasonable excuse. Of course, representing my client, I submit that it is, and Florida law certainly does favor an adjudication on the merits, and that didn't occur in this case. But again, I will submit that the stronger argument for the mother is that she didn't receive proper notice as to the advisory hearing, and if the court agrees that the written form doesn't comply with the statute, then regardless of her reason for not showing up, it still wasn't a properly noticed hearing, and the consent must be reversed.
Let's assume that the consent default order should be vacated. Let's assume that. What would be the practical effect in this case?
If you agree that the written form was insufficient, doesn't comply with the statute, which I submit it does not, then this case needs to be remanded for an adjudicatory hearing. Because at this point, there has not been an adjudicatory hearing as to whether or not the department has been able to establish the grounds for termination. A consent was entered, and the case moved forward to a manifest best interest hearing. At the manifest best interest hearing, the court didn't consider whether or not the department established the grounds for termination. The court only considered the manifest best interest of the children. So if you agree that the form was insufficient, then the proper remedy is to remand for an adjudicatory hearing. The consent should be vacated. Thank you. I'll reserve the rest of my time for rebuttal.
Your Honors, may it please the Court, my name is Michael Lee, and I represent the appellee of the Florida Department of Children and Families. The position that the Florida Department of Children and Families takes in this matter is that the lower court's efforts in providing for the due process rights of these children, as well as looking after the best interests of the children themselves, is that the order should be affirmed, as it fully complies with all the requirements of 39806-1E, 39806-1C, and 39810, the two respective termination of parental rights grounds the Department sought TPR under, as well as the manifest best interest section thereafter. The arguments raised by counsel, responding in the order that he presented them, is that first she did not have counsel. And Judge Lewis, I think you asked the question better than I can raise it myself, and that is the record clear that the mother was not represented by counsel at that hearing? And no, Your Honor, it is not. The amended reconstruction of record that's actually before the court, and let's be very frank here, it is a stipulated reconstruction of the record. It does show adequately and fully that the mother was represented by counsel throughout the whole of the case. It does show that Mr. Drumming did ask to be discharged, and that was subsequently granted. But it also shows that the court's language is very critical. He said that the order discharging Mr. Drumming shall take effect, shall be effectuated upon a separate report and order, an order that was not signed until August of that year, several months later. That hearing and a review of the record will also show that option C was taken on that case, on that matter. Option C is the taking exceptions to the magistrate's report, preserving it for a micro appeal, a mini appeal in front of the circuit judge. No counsel in that room, but for counsel for the mother herself, would have raised that option C. And indeed, the recommendations or these recollections of the department do show that Mr. Drumming did seek that option C. Yes, it says Mr. Drumming does not remember, but it is stipulated, and as such, the department's assertions that Mr. Drumming did go on to raise these issues. Indeed, raising the issue that the grandmother be reconsidered, again, in the record itself, it is pointed out that Mr. Drumming brought that up, show that she had counsel. The only argument to make in addition to that is that if it is not clear, if there is enough, one side says, the other side says, to put any doubt there, then I think, as the department's brief shows, Applegate, in order for this court itself, does control to show that the fact is, when absence of a record is there, the deference is given to the lower tribunal that it was, of course, correct. So if there is any confusion, any doubt in this court's mind, deference does go to the trial court. That's exactly pointed in against the assertion taken by Mr. Ufferman, in that he argues that because of the due process rights involved, the disagreement should go in way in favor for civil rights. And I have to remind the courts here, this is a matter that involves the mother's constitutional rights. There's no doubt about that. The department stipulates to that. But unlike criminal matters, and Judge Roberts, you yourself asked the issue about whether or not the standard of review for setting aside a consent is similar in a termination of parental rights proceeding, criminal law proceeding. Mr. Ufferman said that termination of parental rights proceeding have a higher standard. I would have to disagree with that. And the reason being, in following up this argument, is that in a termination of parental rights hearing, you take into account both the constitutional due process rights of the mother, but also the children themselves. In criminal law, you almost ignore the victim, you ignore the other side, and you focus specifically upon the constitutional rights. Indeed, this is true by the standards the courts have set and the legislature in holding termination of parental rights standards to a clear and convincing evidentiary standard, whereas the criminal standard is, of course, to beyond reasonable doubt. The Department does assert that the language and the order from the record and reconstruction is clear. The mother had counsel throughout the entirety of this hearing, and even if she didn't, the point is not she didn't, even if it's unclear, that weighs in favor of affirming the trial court's order, not in ruling against it. In looking at Mr. Efferman's second argument that he takes, that of the second advisory hearing and her plea of consent by default, the court asked whether or not it was excusable reason, I think it was Judge Lewis who asked whether or not a warrant for an arrest was excusable to set aside. And Mr. Efferman responded, yes, it was. And indeed, it was. He added to that it was excusable because she was preparing herself to turn herself in. She was preparing to turn herself in, and she'd attended all the other hearings. The record will show not only did she fail to attend the advisory hearing, she failed to attend the motion to set aside the default later on, that she still at that time had not turned herself in, despite several weeks in between there. Regardless of that, an arrest warrant is absolutely no excuse to set aside a plea of consent. The very case law cited by opposing counsel shows that the only reasons you set aside such a plea is when it is one of medical neglect, one of great bodily harm, act of God, or those circumstances that are truly beyond the control. Now, Mr. Efferman is correct that there is strong public policy to favor a hearing on the merits of the case. But that public policy is not there to protect parents or even clients of their own actions, lack of actions, or improper actions. It is there to allow for meaningful review on appeal, a meaningful hearing on the actual merits itself. And that took place regardless of anything else that happened. Judge Lewis, you also asked what would be the meaningful result of setting aside this default and sending it back down to a lower level. Mr. Efferman responded that it would allow for an adjudicatory hearing on the merits. That is true, and it would, but the fact is that did take place. At the manifest best interest hearing, this was not a simple one-witness, two-witness issue. The Department of Children and Families basically proved its case in chief anyway. The issues that go to proving manifest best interest in the 39-810 are highly similar to those very issues under the grounds themselves, in that to win and prove a successful termination of parental rights, the Department has to show that some statutory ground is there. And the two we played were, of course, case plan failure under the E ground and the engaged in conduct that threatens the health of children regardless of services, the C ground, but also that it's in their best interest. And what evidence does a trial judge rely upon in determining best interest other than those grounds themselves? Has there been any effort to rehabilitate this parent? Is there any visitation? Has the case plan been effectuated? Is the conduct so bad that it will threaten the children regardless of anything else? All of that evidence was placed before the magistrate, at the manifest best interest hearing. He heard the testimony from a mental health expert, the therapist of the children, Dr. Love. He heard about the children's struggles with their mom, about the fact that they had gone through horrendous conduct, including one of them being sexually abused by the mother's paramour during an act of domestic violence, an act that only occurred after she absconded from this court's jurisdiction after getting an unfavorable ruling in court. He heard from the testimony from the guardian ad litem about the way the children were doing when they were going back and forth between foster care and their mother, and how they were doing in response to their separation and all the other elements of abuse. But more importantly, and this is supported by Dr. Love in the guardian's testimony as well, the court heard from the mother herself. The court heard testimony that she had indeed failed her case plan, that she had missed multiple random urinalysis, that she had even taken in someone else's urine to one of these tests that had been caught in the act of it, that she was not without stable income, she was without stable income, without stable housing, that she had absconded from the jurisdiction and protective supervision of this court, and that during that, her oldest child, the only female child, was heinously sexually abused by the mother's relationship paramour. The paramour that the case plan and the evidence before the court shows should never have been around those children to begin with.
Mr. Lee?
Yes, Your Honor.
Could you circle back to the issue of the notice? I'm a little concerned the fact that the notice that was the notice to appear that the mother signed didn't have that element that said failure to appear constitutes consent to the TPR.
And the first thing I would point the court out to is, again, the mother's testimony at the manifest best interest hearing. Mm-hmm. She was asked pointedly on the record, do you remember receiving notice of the advisory hearing? Her answer was yes. Do you remember hearing what the consequences there were, that your rights could and would be terminated? Yes, I do. And yet you failed to appear. Yes, I did. Why did you fail to appear? There was a warrant outstanding for my arrest. I do not argue that the record and transcript put before the court by motion of counsel shows that no oral colloquy was given the day of the advisory hearing. That is proven by the transcript. It shows that, as is common in one of these mass docket hearings, there are multiple issues before the court, that there was argument between counsel, and it became a little fractious at some point. And over the objections of the department, who routinely opposes any continuance, the advisory hearing that was set that day was continued to a later date and time, and that the colloquy was not shown in that transcript. But what we do show is that the mother had been through an advisory before, that she had full notice of the consequences of her actions, and that she failed to appear. The signed notice, again, just reinforces that. No, it does not strictly conform with the statutory language. But
must the notice strictly comply with the statutory language? Can it be similar?
Your Honor, I do believe that it can be.
How substantially similar must it be?
Yes, Your Honor, I do believe that it can be similar. No, it does not have to substantially comply. This court itself reviews motions and appeals all the time, arguing that the colloquy was not sufficient on criminal convictions and criminal pleas and other civil pleas as well. And the court looks to see, in terms of the similarity you're looking for, Your Honor, looks to see if the essence of the warning and the notice is given to a parent, if they are aware of the consequences that could happen to them. It does not have to be certain. It is disingenuous to say that it is certain because, as counsel pointed out, more often than not, deference goes to setting aside and not granting it. The point is, the person whose rights are being protected must have ample notice of what could happen should they fail to appear. They must be given opportunity to appear at that hearing, notice thereof, and that's it, Your Honor. Anything else gives them more due process rights than they are arguing. And that is actually another issue on contention on this issue between the department and the mother, is the argument that a second advisory hearing should never have taken place as not statutorily called for. The frustration that the department has in this case is that, one, it defies the statutory goals of permanency. This case started in 2002. It is a 2007, and in a statutory scheme that demands permanency in 1 year, we failed that by almost 500, 600%. The reason for that are the countless delays and continuances in this matter. Responding to the first argument right to counsel, the court will see that that was, again, another issue caused by the mother herself. The department's brief and the record are replete with continuous firings and hirings of counsel. Despite that, knowing that this was a termination of parental rights proceeding, knowing that the delays were causing harm to the children, the court, the magistrate, many times over the objection of the department itself, granted continuance after continuance to afford her the opportunities to appear in court, to afford for her due process rights. And then when an arrest warrant is there, when all notice is given to her, she chooses not to come. The department would argue once again that is yet more support that any error that the court may find here, should there be any, again our contention is there not, would simply be harmless. Should this matter be remanded back to the trial court, the only thing the court would be serving is to, in some extent, waste judicial economy and require another termination of parental rights hearing to prove the exact issues that were so easily proven here. Mr. Ufferman argues that's not the case. That should the mother be on notice of the grounds themselves, she can prepare a more adequate defense. Her testimony is her testimony. And under oath, she attested and adequately proved both grounds for termination of parental rights. Supported by Dr. Love's testimony of these children's harms and the fact that, but for termination of parental rights, they will forever stay in crisis. That they will never be safe and never survive to adulthood. There is no point in sending this matter back. Any error here is absolutely harmless. And it would only serve to delay the permanency needs of these children once again. And the department will propose to the court. It will be delaying permanency at the actions of the mother and her own attempts to cloud this record. And that is another issue here. All the standards of review on these issues, and they do vary between de novo, competence of substantial evidence, and, of course, abuse of discretion, to some extent place the burden here on Mr. Ufferman and on the mother to show to this court, back to your first question, Judge Lewis, that there is clear error. There is no clear error. Between the two records being lost, the amended reconstruction of the record, all the other issues and attempts we made to adequately provide for the mother's due process, yet at the same time provide for the permanency of the children, prove to serve that this matter has no reversible error contained within it, at least no proof thereof.
In regards to the mother's motion to set aside the default judgment, the courts have set forth a three-pronged test which the trial court must consider in ruling on the motion. Is the trial court required to explicitly address all three prongs of the three-pronged test in ruling on the motion?
Your Honor, the trial court has tremendous discretion in this matter. Again, the standard of review on this issue is an abuse of discretion, and no, the trial court is not required to find all three prongs there, but is simply forced to find that if one is so overwhelming in favor of a parent or any individual whose rights are in question, to go ahead and give them the deference thereof. But this matter, and this is one of the points taken in the department's brief, was not even preserved for appeal because the mother did file a motion to set aside the default, failed to show up at that hearing, and failed to present any meritorious defense. Her testimony could not even be taken. Not a single prong was given to the court on the day of that hearing, and the trial court properly denied the motion to set aside the default. Again, testimony would later show at the MBI hearing, when asked and forced to put this on the record why she appeared, the only reason she had was that she was scared of being arrested. And as the department argued then, we are certainly arguing now, any parent who puts such a risk above the welfare and safety of their children, above their own parental rights, and, Your Honor, there is no point in sending this back for any further hearings. So on the abuse of discretion standard, the trial court has to weigh all three of those, determine which ones favor ultimately greater due process and greater justice, and this court has to step aside, not step aside, but look at the magistrate and see whether or not he abused his discretion. In this case, he did not. When there was no witness presented to show whether the motion to be set aside, there's nothing to consider. And again, that matter was never appealed. Before this court today, the notice of appeal only goes to the actual termination of parental rights order. We would argue, of course, because it was recommended by a magistrate and then later effectuated by a circuit judge, that both of those issues are on appeal. But the motion to set aside was held many months earlier. It was denied, never appealed. I don't even believe exceptions were taken to the circuit judge, raising another barrier to appeal, possibly based on some dicta this court has issued in its opinions. There is nothing before this court to show that the mother had any meaningful reason to set this aside, ever sought to do so, and certainly nothing to show that it's justified in being set aside. Your Honor, just briefly, everything before the record of this court shows that the court struggled with balancing the due process rights of the mother and the permanency agenda of the children. Our argument today is that it got that as close to right as possible. We don't acknowledge that there are hiccups in this record, losing two parts of the record to begin with. We do acknowledge that there are issues where the court had to deviate from the statute in holding a second advisory and dealing with the referrals from the magistrate to the circuit judge. But everything that was done was to protect her due process. I have no doubt that should the court have not given a second advisory, we would be here today arguing that because she was never formally advised, there's a procedural misstep, and we have to go back and try again. Likewise, Your Honor, with the children, their permanency demands this termination of parental rights. I have nothing further.
For the first advisory opinion, was there a notice that fully complied?
Your Honor, I do not remember, and upon reviewing the record, I don't know. I do not see a written notice that says that. I believe the notice that is done for the Leon County Circuit Court is the same notice on all the hearings. I would have to review the record fully to see and pull the transcript, as Mr. Ufferman did, to see if there was an oral colloquy given. Again, looking at the past practices of the dependency court on mass docket, even if there was an oral colloquy given, they vary. Sometimes the colloquies can take, depending on what judge is covering, the colloquies can last 5, 10 minutes, and sometimes they last 5 seconds. It goes back to Judge Lewis's question that the point is to convey to the client what their rights are, that they have to be there when it is, and what the possible consequences are, not certain. See, my time is concluded. I have nothing further. Thank you, Your Honor.
Thank you.
May it please the Court. The Department concedes that this form does not strictly comply with the statute, and strict compliance is required. That's exactly what the CRK case from the 4th District says, and it's disconcerting to hear that there is nothing in the record regarding any written form from the first advisory, Your Honor, but if the same form is being used, was used in this case, and is still being used, the form is not in compliance. The Court needs to let the Circuit Court here in Leon County know that this form doesn't comply with either the statute or the rule, and it's not substantially in compliance. It's missing one of the two prongs. There's two prongs there. One that says if you fail to show up, your rights may be terminated. Way more importantly, if you fail to show up, it will result in a consent. And that's what we're here about today. It's not her rights may be terminated. She didn't show up, and it resulted in a consent. What it didn't tell her is what actually came back to bite her. She was never given the proper notice. I don't necessarily understand the Department's argument that the mother's testimony at the MBI hearing somehow establishes that she was given notice. Whatever mistaken memory she has is conclusively refuted by the transcript itself. And it's clear in the transcript that the magistrate never told her, never said anything on the record that if you fail to show up at the advisory, it will result in a consent. And again, the Department talked today about sometimes these colloquies vary. They shouldn't vary in every single case. The colloquy should say these two things that are required by statute, required by rule. It wasn't done in this case. She wasn't given proper notice. The Department talks about the actions of the mother in delaying this. This form is not the action of the mother. She didn't create this form. She only signed the form that didn't give her notice of all of her rights, and she's now suffering because of that. I submit that the MBI hearing cannot substitute for an adjudicatory hearing. You would have to be put on notice as to what's going to be presented at this particular hearing. You'd have to be put on notice. You have a right to go and defend against these grounds that the department is alleging that you're somehow going to lose your parental rights. She wasn't given any notice in that regard. The only notice that she was given is that she's going to go to a hearing and defend against whether or not termination is in the children's best interest, not defend against whether or not the department established the grounds for termination. There's never been a hearing to determine whether or not the department met their burden in this case regarding the grounds for termination. That's because there was a consent that was entered after there was a form that was erroneous because it didn't give her proper notice as to what would happen if she failed to show up at the advisory hearing. Going back to the counsel issue, I just briefly point out to the court some record cites. The stipulation appears at page 1085 of the record. And again, it's paragraph 1 where the stipulation clearly states that at the beginning of the hearing, the magistrate granted the motion of counsel to withdraw. That conclusion is supported also by the magistrate's report from the July 29th hearing, which appears, I'm citing to page 801 of the record, and in paragraph 9 on page 801, the magistrate says, Mr. Drumming was discharged as wished by the mother. So the magistrate acknowledges in the report from the July 29th hearing that counsel was discharged at that hearing. Now, there's
What about the further statement that it would be effectuated by a separate order? In other words, that it would come to pass until that separate order would be entered, and that wasn't until August.
I don't think, and this is just a common sense argument in response to that, there's lots of things that happen in court every day where someone makes an argument and there's not a written order ready to be signed right then. And the court will often say, provide me an order, I'll sign it. But the court is making is orally granting the motion right then, and it's effective.
But the court also says the mother was noticed at this hearing, did appear, and was represented by counsel.
At the beginning of the hearing. And then
He doesn't say at the beginning of the hearing.
the stipulated record, the stipulation from the party says that. So we know that at the beginning of the hearing, she was represented by counsel, and then shortly after the beginning, because, again, my argument is it appears in paragraph 1, that the court went ahead and granted the motion for counsel to withdraw. So it's my contention that based on the fact that the stipulation contains this language in the first paragraph, and the fact that the court did acknowledge that the counsel's motion to discharge was granted, that the mother was not represented by counsel at that hearing. Thank you very much.
Counsel, just a final question in regards to the notice. Must the notice expressly strike the language of the statute, or can the notice be similar to the language of the statute? And how similar must the notice be?
Your Honor, to answer that, let me read. And while I'm looking at this, my initial answer would be it must at least contain language regarding both prongs. The prong that if you fail to appear, it can result in termination of your rights, and if you fail to appear, it will result in the consent. But the 8.505B says the document containing the notice to appear shall notify the required persons of the filing of the petition and must contain and type at least as large as the balance of the document the following or substantially similar language. And there's two sentences there. The first sentence deals with the consent. The second deals with what will happen, that your rights may be terminated if you fail to appear. There is nothing in our notice regarding the consent. There's two prongs here. And the consent prong, again, I submit, is the most important prong as far as my client is concerned, because the consent was entered because she failed to appear. Yet she was never told that if she failed to appear, it will result in a consent. So I submit that maybe there's other language out there that could be similar, but it must at least refer to the fact that if you fail to appear, it will result in consent. My position would be if there's nothing in the form that talks about consent being entered if you fail to appear, the form would not be sufficient. It would not be substantially similar. Thank you.
Thank you, counsel. That concludes the court's docket for today. We're adjourned.